My name is Jeff Morgan. I am from Dallas, Texas. This is December the 26th, 2022. So for those who celebrated Christmas yesterday, Merry Christmas to you. It is a great day when we remember the birth of our Lord Jesus Christ. I want to read this letter brief as an amicus curiae in a matter pertaining to Mr. Jeffrey Younger, and this is number 22-1137. For those of you who don't know, Jeff Younger is the father of two boys, twins, James and Jude, named after the brothers of Jesus Christ. And currently what has happened is that in Dallas County, we have had some very abusive things that have taken place in the court of Judge Mary Brown, the 301st District Court, and there have been a lot of attorney shenanigans that have taken place at the same time. Anyway, Mr. Younger wrote a writ of mandamus that he submitted to the Supreme Court of Texas, and I'm going to read the response from Judd E. Stone II, Solicitor General of the state of Texas. And he's submitting this, he's writing this to Blake Hawthorne, the clerk of the Supreme Court of Texas. Dear Mr. Hawthorne, the state of Texas, by and through Attorney General Ken Paxton, submits this brief as amicus curiae in the above matter. In the state's view, the petition for relief should be granted, and any appropriate administrative or emergency relief should immediately issue to preserve this court's ability to review the relator's claims in an orderly fashion. The petition seeks relief that this court may grant. Although styled a petition for a writ of mandamus, relator seeks an order that, in essence, stays the trial court's September 21st memorandum ruling and prohibits the court from taking further actions that will allow or assist relator's former spouse to remove his children to California. As the order seeks to prevent a trial court from taking further action on a cause, it may be more appropriately styled a petition for a writ of prohibition. In different case law cited here, such a writ operates like an injunction issued by a superior court to control, limit, or prevent action in a court of inferior jurisdiction. The same standard applies whether relator's petition sounds in mandamus, prohibition, or both. The petition seeks relief that the court should grant. This court has repeatedly stated that mandamus or prohibition is an appropriate form of relief when the relator can establish that a public official has committed a clear abuse of discretion. A clear abuse of discretion, and no adequate remedy exists on appeal. Once again, additional case law is cited. This is such a circumstance. A trial court has allowed relator's former partner to move to California with their children over relator's objection. There, she intends to provide the child with potentially irreversible medical interventions that may constitute child abuse under Texas law, Attorney General Opinion KP-0401, particularly given that a court has previously found that, quote, mom may have overcorrected, unquote, for any symptoms of gender confusion exhibited by their child. The trial court clearly abused its discretion in permitting relator's former partner to remove the child from the state given the ongoing litigation regarding their well-being. And that error may be irremediable on appeal because California has enacted a law that makes it difficult, if not impossible, for a relator to gain custody of his vulnerable child. And a link is provided here to where that may be downloaded. The need for relief in this case is particularly acute because the question presented here is both of constitutional significance and likely to recur over the next 9 days. As the California bill itself acknowledges, quote, the United States Constitution generally requires a state to give full faith and credit to the public acts, records, and judicial proceedings of every other state, unquote. Yet California passed SB 107 specifically to deny such treatment to Texas laws and court orders because of policy disagreements with the, quote, far-right anti-LGBTQ governor Greg Abbott, unquote, and the putative fact that, quote, Texas began investigating and potentially prosecuting parents of trans kids who receive gender-affirming care, unquote. The law is set to go into effect in just 9 days, meaning that the enforceability of an unknown number of Texas child custody orders will be in jeopardy if this court fails to provide relief. The petition also reflects that relator has a compelling reason to seek relief from the court in this instance. Although the state has not been involved in this case to date, the petition reflects that the trial court delayed entering an order necessary to seek further relief for 3 months. When time is of the essence through no fault of the relator, as here, this court has not hesitated to exercise its mandamus authority. Again, additional case laws referred to, the court should do so again. Finally, this court should immediately issue administrative and emergency relief staying the trial court's order and prohibiting the removal of the child from the state while it considers the relator's petition. California has directed its courts to assert temporary emergency jurisdiction over children who are unable to receive controversial medical interventions in other states, SB 107, and relator's former partner has indicated that she will seek to have the ongoing matter transferred to California courts if she is permitted to relocate there with their children. This court has, quote, all powers necessary in the aid of its jurisdiction, unquote, which may be irretrievably lost if relator does not receive immediate relief to prevent his children's removal from the state. This court should issue such relief. Respectfully submitted, Jude E. Stone II, Solicitor General for the state of Texas. The certificate of service is down here too. On December the 22nd, 2022, this letter was served on all counsel of record through the court's e-filing system. Certificate of compliance, the Microsoft Word reports that this letter contains 887 words excluding exempted text. So automated certificate of service was done to Jessica Janasek of Kuntz Fuller Law Firm, J. Janasek at kuntzfuller.com, Amy Murray, A. Murray at kuntzfuller.com. The certificate of notice through e-service was given to Catherine Nicholson, C. Nicholson at dallascounty.org, and I believe that she is the clerk for Mary Brown, the judge of the 301st District Court. And the case contacts, we have Jude E. Stone, judd.stone at oag.texas.gov. And this is time stamped December the 22nd, 2022 at 8:24:31 p.m. The status is sent. I want to address this further because, as many people know, Mr. Younger has been fighting for his children, both James and Jude Younger, who have been taken from him by an abusive judge and by a judge who, as this letter says, exercised a clear abuse of discretion and gave the children to the mother. Now, what the background of this case is that Ann Georgelis, who was a pediatrician who was working out of Coppell, Texas, who had a pediatric practice there, she retired earlier this year, and what was later found out through a friend of mine is that she actually opened up a practice, or at least she has a certification to practice in the state of California. This was done at the beginning of September. Now, the case went to trial, to the hearing before Judge Mary Brown in September, and Mary Brown issued a ruling, a memo ruling, on behalf of Ann Georgelis. And basically what she did in that ruling was terminate Mr. Younger's parental rights, gave Ann Georgelis, pediatrician Ann Georgelis, the right to take the children anywhere in the United States, to get a passport apart from the father's consent, and to not even have to tell the father where the children were. In effect, what she did, she issued a termination order against Mr. Younger, a parental right termination, and her justification is that Mr. Younger would not see James, who had, if he wanted to see James, he had to go and do some type of supervised visitation, and James was allowed to present himself as a girl, something that embarrass James, something that James did not want to do, something that James did not want his father to see. And Jeff Younger refused to participate in the abuse of the child. And this was child abuse. This is child abuse. It's making a minor child basically dress up as drag. It's not just drag queen story hour. It's drag queen participant for all intents and purposes that Ann Georgioulas is doing, and that Mary Brown of the 301st District Court is defending, and that Jessica Janicek of the Coonsfuller Law Firm was seeking to be able to allow Ann Georgioulas to do. Just on the face, it appeared that there was already a predetermined outcome to this. Otherwise, why would Ann Georgioulas have opened up practice in California? She was moving there very specifically because of Senate Bill 107 that was passed earlier this year that would allow the state of California specifically to deny such treatment to Texas laws and court orders because of policy disagreements with the far-right anti-LGBTQ governor, Greg Abbott. This was designed specifically so that anybody who had, quote, a trans kid could move to California and have the surgeries performed on the trans kids, or the chemical surgeries, whatever, the drug therapy, the hormone suppression treatment, whatever it may be. This was considered to be a very caring act that the governor did to help the trans kids. There's a lot of issues with this. First off, what is a trans kid? Nobody really knows. Is trans kid something genetic? No, it is not. Is trans kid a psychological issue? I would argue, yes, it is. Trans is not a biological issue. It is a psychological issue. And in the case of Mr. Younger's son, James, he actually didn't even have this issue. This was something that the mother was forcing upon him because of something that he did when he was about 2 to 3 years old. He saw a shiny toy in McDonald's, and at that point in time, the mother, and not the biological mother, she is the mother, but she's not a biological mother, the non-biological mother of James decided that James was a trans son, that he was going to be converted to a girl through a number of specific treatments, which include hormone suppression treatment, social transition, and everything else. So she was convincing James at the time that he was a girl. There's a video out there that says, "Mommy says I'm a girl," in which Mr. Younger says, "You're not a girl, you're a boy. How is it that you're a girl?" "Mommy says I'm a girl." Mommy used to say that would do things to either withhold love from James or to scare him into being frightened if he were a boy, and basically ended up brainwashing him to try to make him feel that he was a girl. Now, when he was around his father, he never, ever exhibited these symptoms. I've been to Mr. Younger's house. I saw the closet where James Younger's clothes used to be. And what had happened is that Mr. Younger put clothes in there, both boys' clothes and girls' clothes. One evening, James took the girls' clothes, including the panties and everything else, and threw them in the garbage. He was a boy. You can see videos of him boxing. He's a boy through and through. I've met James Younger. He is a boy. This is brainwashing by the mother that's taking place. And the court clearly abused its discretion in allowing the mother the ability to do this. The issue is of constitutional significance because the United States Constitution generally requires the state to give full faith and credit to the public acts, records, and judicial proceedings of every other state. And Governor Newsom and the other people out there decided they did not want to do this. They wanted to be, quote, trans-friendly. They wanted to advance the gender ideology of transgenderism. And that's why they passed this bill, which violates perhaps the U.S. Constitution. This was an attack on Texas. It was an attack on Greg Abbott. It was an attack on Mr. Younger, as far as I am concerned. California has taken other children out there and have put them through this transgenderism process apart from the knowledge of one parent and over the protest of a parent. What it does, it gives the parent who wants to transition a child, either a boy or a girl, the ability to do so, and the other person basically is the abusive parent because he or she is not acknowledging the child's trans identity. And once again, it is an identity. It is a psychological issue. It's not a biological issue. If you were to look at the DNA of James Younger, his DNA would be 100% male. There's no trans DNA. He is a male, a biological male. And his brother Jude also is a biological male. So this whole transgender ideology is anti-biology, anti-science, and it's an ideology that some in the trans community are trying to foist upon society. And I found it very interesting because I was at the trial with Mr. Younger about 4 years ago, and there was a, quote, trans person down there. I think it was a boy who was presenting himself as a woman right now, about late 20s years old, and she said to me, I knew from when I was very young that I was a girl, but dear God, do not do this. Do not do this to kids. This was a trans person speaking. And for people that say, well, we have to have trans rights, trans people, if there are such things as trans people, they are offended, many of them, that you would accuse them of aligning with this type of abuse. I've talked with lesbians who hate what's going on. In fact, one lady who's a very flaming lesbian says that this is one of the most abusive things that she has ever seen, and she opposes it 100%. A few other things is that, number one, this should not even have been an issue. This has been on the Republican platform at least last year and this year, that any type of surgery like this, any type of gender mutilation surgery it should not be allowed to take place among minor children. If people get of age and they want to do it, it doesn't address that. But for children, especially when one parent wants to force it upon a child who does not want to be a girl, a boy who does not want to be a girl, or a girl who does not want to be a boy, this is nothing other than plain abuse. And for Judge Mary Brown to permit this to take place, Judge Mary Brown is guilty of abuse. I actually did call CPS on her and upon the attorney there, Jessica Janasek. CPS did not do anything, unfortunately, to the best of my knowledge. Perhaps I called up the wrong number, I don't know, but CPS let them off the hook, evidently. Again, you have a law firm, Kuntz Fuller Law Firm. Kuntz Fuller Law Firm with Jessica Janasek. I've been in court, I've watched Jessica Janasek. Jessica Janasek has done everything that she could to try to enable the mother to permit this abuse. Jessica Janasek, I think, has 4 children. I doubt if Jessica Janasek would like it, or that her husband would like it, if this abuse were forced on their children. But as an attorney who's making money off of this whole thing, Jessica Janasek will defend the mother in this situation and try to make sure that this happens. So what I am thankful for, though, in spite of all the failures that we've had in the state of Texas, legislatively we have failed to do this. We have not taken the lead on this. We should have. This is abuse, child abuse. When the head of CPS at the time, Jamie Masters, said it was child abuse, when we all know it's child abuse, when we all know it's gender mutilation, this never should have been permitted to happen. And yet our courts somehow think that they are allowed to do this. And courts and attorneys who advance this agenda, I believe that they should be found guilty of all sorts of heinous crimes. But fortunately, at this point, at least we have Jude E. Stone, the Solicitor General of the state of Texas, who has said that this court, the Texas Supreme Court, should immediately issue administrative and emergency relief, staying the trial court's orders and prohibiting the removal of the children from the state while it considers the petition. The reality is, at this point, to the best of my knowledge, Ann Georgelis has already removed the children out of state and taken them to California. They're not exactly sure where she is. She has done this because this was a predetermined outcome that somehow Kuntz Fuller or Jessica Janasek evidently negotiated with Mary Brown, and Mary Brown signed off on it. So if you wonder why I was so much against Mary Brown in this last election, this is part of the reason. Because Mary Brown is an abusive judge, and in addition to her ethical violations, this is completely inexcusable what she has done. This court has all powers necessary in the aid of its jurisdiction to issue this relief, and it should. One other thing I want to mention is that the law firm Kuntz Fuller and Jessica Janasek. So I saw the memorandum order that was issued, I believe it was the middle to the end of September, and it was never put out as final order. This is a dirty attorney trick, a dirty law firm trick, in my opinion. What they did, they waited 90 days so that when the order came forward, if it even has come forward yet, I'm not even 100% sure that it has, but they waited so that Mr. Younger would run out of time and not be able to file this mandamus, this writ of mandamus, or this writ of prohibition. This attorney firm, this law firm, Kuntz Fuller, which prides itself as being such a wonderful law firm, I believe that they should be investigated for abuse too. They are part of the apparatus that is involved in this abuse. Jessica Janicek should be investigated for abuse. Mary Brown should be investigated for abuse. And it is my hope that the state of Texas, the Supreme Court of the state of Texas, whom I know has in the past have wanted to weigh in on some of these issues, will issue the right opinion and will actually find relief for Mr. Younger. I also believe too that Dr. Ann Georgilis should also be arrested for parental kidnapping, and I believe that the court, Mary Brown, and also the attorney, Jessica Janicek, should probably be arrested and tried as being accomplices of this parental kidnapping. So anyway, this is what's going on right now in the state of Texas. It is the 26th of December. Jessica Janicek and has until the 28th of December, I believe it is, to reply. I think she had 5 days, so I think she has to reply to this by December the 28th. But again, this is something that's of the utmost importance, the utmost urgency. If you are a parent, if you are a grandparent, if you are somebody who loves your children, your grandchildren, your nephews, your nieces, whatever, you need to be following this case. Because what they're saying is this: the state can take your kids from you and give it to a parent who wants to perform a gender experiment, who can pretend to change the gender of your kids, who can mutilate your kids, your grandkids, your nephews, your nieces. What the courts are doing right now, they're trying to say is that as a parent, as a grandparent, as an uncle and aunt, you have no rights. Anybody who wants to transition somebody, they have full rights. So watch this case. I'll update later as I get some information. But this is, again, is what's happening in the state of Texas. Thank you.